so much. I'm really excited to be
Back
talking.
up a little bit so we can see you better. How about right here? Yeah.
Okay.
And also, as far as that, I'm really glad to be talking to you today about students' rights. I'm going to focus mostly on the K-12 context and talk about two sort of main topics and some really interesting, what I think are the kind of cutting-edge legal issues, and also some really recent developments with case law that came down just this week. Okay, so for the first half of the presentation, I wanted to talk about the intersection. Is this on?
Yeah.
Let's make sure.
Hello? Yes, okay. So for the first half, I wanted to talk about the intersection of harassment and bullying with free speech rights. And then I also wanted to talk about law enforcement on campus. So with respect to harassment and free speech rights, I think the ACLU is a uniquely situated organization to address these issues because, unfortunately, sometimes the right to have an education free of harassment and discrimination can come into conflict with free speech rights. Why is that so? Because bullying and harassment often takes the form of speech. So when does an insult, an epithet, cross the line from protected free speech rights to conduct that the government, the state, the school, or whoever else, whatever other portion of government can permissibly punish? These are really, really interesting issues. They're very difficult issues, and I think it's incumbent upon us, the ACLU, as an organization that's committed to all of the amendments, not just 1 or 14, but all of them, to try to balance these really important interests. And I think there is a way to do it, but we have to be very mindful about that. So I think as a general matter, our goal with respect to our harassment and bullying work is prevention. So the appropriate approach is to prevent bullying before it happens by getting to the root causes of bullying, encouraging schools to foster a climate of inclusion and a tolerance of difference. So what are we doing about that? Right now, the ACLU is at the forefront in California of sponsoring legislation, AB 9, authored by Assembly Member Tom Aviano, and it's called Seth Law, after Seth Walsh, who I'm sure many of you read about in the newspapers last year. He was a young man in Tehachapi, California, who tragically committed suicide on September 19th of last year by hanging himself in his family's backyard after years and years of intolerable bullying based on his sexual orientation. Fortunately for Seth, he had a very supportive family, but that wasn't enough. The school didn't step in. It didn't take the measures that were absolutely necessary to save that young man's life. And the thing that's quite tragic, obviously any life is tragic, the thing that's quite shocking is that he was one of at least 11 suicides that we know of LGBT in a 3-month period last year. So the statistics are quite stark, and obviously more needs to be done. AB 9 is a modest but important step towards that. Our bill would basically require all school districts, to the extent they have not already done so, to have active anti-harassment programs, to build a curriculum, to build a program towards building a climate on campus that is one of inclusion and respect for differences. And it would also require schools to have systems in place so that parents and students can actually file a harassment complaint through a transparent process that they understand, and that the complaint will be acted upon quickly and promptly. Now, there are a few portions of the bill that we included and that unfortunately are not, were taken out of the bill. And they're very important elements that I also want to touch on briefly because it goes to the other issue that I was talking about, how to balance preventing harassment with free speech rights and what you do with the bulliers. We had included 2 other aspects of the bill that are no longer in it right now. We're optimistic. And one aspect, a key aspect, was to establish alternatives to discipline. So when you have the bullier, your instant reaction as a school is not to suspend or expel the kid, but to work with the kid and get to the root causes. Suspension and expulsion, just going straight to punishment, is not going to help that child understand what was wrong with the conduct. And an emphasis that relies primarily or exclusively on discipline is ultimately, from a policy perspective, extremely counterproductive because 1, it doesn't get to root causes, and 2, it often backfires on us, on the protected groups, because what do we see? We see that the students who suffer disproportionate discipline instead of the perpetrators. So for many reasons, we're absolutely opposed to a system that focuses on discipline, and we want to emphasize alternatives to discipline. The other portion of our bill, which we are hoping to get back into the bill, is ongoing professional development for staff and training them in how to cope proactively with bullying. So right now that bill is pending. It passed that assembly successfully, which was a great victory. It's pending in the Senate, and it's up for a hearing in the Senate Education Committee next Wednesday. Seth Mother, as she testified in the Assembly, will also be testifying again in the Senate, as well. One of my colleagues from San Francisco, Diana Tate-Vermeer, who is our racial justice project director, and she's authored many aspects of this legislation. And we are right now continuing to work with the leadership of both the Assembly and the Senate to try to get back in the provisions for alternative discipline and ongoing staff development that we think are so crucial to a comprehensive approach, proactive approach to bullying. So that's what we're doing on the preventing bullying front. What about the other sort of, I don't know if half of the equation is, but the other aspect of the equation, which is how do we protect speech rights as well? Again, so I don't want to hit more of a sort of create more of a conflict than there really is, but I think whenever you look at bullying, you have to understand that there are also speech rights at issue, because students absolutely have free speech rights to say things, and sometimes it's a very, very murky border between protected opinion. Some student may have a deeply held, sincere religious belief that homosexuality is not consistent with his or her religious tenets. And that student absolutely has a right to hold that view and to express that view. But what that student does not have the right to do is to engage in speech or conduct that creates a hostile educational environment that deprives another student of the right to equal access to educational opportunities. I think that's particularly important to think in the school context, that it's also not the same as my yelling an epithet to you out on the street. Because on the street, you're not captive. You're not my captive audience. When you're in school, there are mandatory school attendance laws. You have to go to school. You're stuck in this little fishbowl. And so the considerations for speech are different in school context than it would be out on the sidewalk. But that's a very complicated difference that I'll come back to in a minute. So talking about the speech rights, this is fascinating, and I could go on forever, so I'll try to just give you the big picture, give you a sort of legal framework of the big picture of free speech rights in the education context, in the K-12 education context. So the seminal student free speech case comes from the Vietnam War era. It's called Tinker v. De Royne, and it was about 3 activist students in high school who wanted to wear black armbands and protest the Vietnam War. And this was considered very, very controversial at the time, and they basically got suspended for doing so. The case went all the way up to the U.S. Supreme Court, and the court made absolutely clear that students do not shed their constitutional rights once they cross the schoolhouse gates. They continue to have free speech rights protected by the Constitution even when they're in school. However, there are certain specific considerations unique to the educational context. What I was talking about just now, that it's this captive audience, that you have a mandatory compulsory education laws, so that the school, the government, when it's acting as a school, has a unique interest in trying to preserve order of the educational environment, trying to deliver education to all of the students. So in that context, the government, the school, has more authority to regulate your speech than it would if we're talking about the police or city trying to regulate your speech as a citizen who's out there on the street. So Tinker basically set up the standard that said, while students absolutely have constitutional rights to free speech, they're slightly different and they're a little bit more limited in the school context. And so the school can only punish speech that causes a substantial disruption to the school environment or invades the rights of others. And that's a very interesting standard, substantial disruption. So normally, if you were out on the street, the government absolutely cannot punish you for speech that causes a disruption, right? So that's the classic, you can't regulate speech. In the normal First Amendment principles, that you can't regulate speech just on anticipating that it's going to upset someone and then it's going to cause a ruckus. providing education, meeting order, the educational environment with student speech rights. So they don't have nothing, but they don't have as much as they would out there on the street. So that's the sort of key case. There are also a couple other cases that are also relevant to bullying and harassment that I'll just mention quickly. There's a strange little exception, a couple little quirky exceptions that the Supreme Court has carved out. There's basically the exception for lewd speech. So there was this case of this young man named Frazier who delivered at a school assembly a long speech that was an elaborate sexual metaphor, and he was disciplined for that. And the Supreme Court said that's fine because the school can regulate lewd speech in the context when it occurs on school grounds. Another exception is when the speech has the imprimatur of the school, so it appears that it's the school speaking. So, for example, a student newspaper. If there are legitimate pedagogical concerns, the school can basically engage in some censorship. Now, that's federal law. State law is different. State law is more protected. There's certain California Education Code provisions that actually go beyond what the First Amendment protects. It actually allows student newspapers and student journalists to exercise independent editorial control, separate and apart from the school. So that's a state statutory right that doesn't come from the First Amendment, and those state statutory rights are more robust than the federal Constitution. And then the weird other little quirky exception that the Supreme Court has carved out is speech that that promotes illegal drug use. Sometimes you get, there's this expression in the law, like bad facts being bad law. So you get these very strange fact patterns. And there was, I'm sure you guys have heard of this case, the Long Hits for Jesus case. It was a student in Alaska who was he was not physically on the school grounds, and he had this shirt or sign or something that said Long Hits for Jesus, he was just trying to get attention. And he got disciplined where he could do that. The U.S. Supreme Court created some sort of, was it a school-sponsored activity? Oh, I don't know, it's confusing, but they just said, okay, well, if it's speech that is promoting illegal drug use, then we can regulate that too. So that's just a weird sort of one-off exception. I don't know how much that's going to really come up again. But the key rule, basically, in the school context is this tinker rule. This government, school can punish speech